So we're going to be getting started. And once again, thank you for tuning into our National Digital Teaching Back to School series, part 1 of 3, Know Your Rights, Police in Schools, Digital Privacy, School Surveillance, and Arrest and Detention, hosted by Policing Free Schools alongside our partners, British Columbia Civil Liberties Association. Before moving forward, we would like to acknowledge that we are on stolen Indigenous land across Turtle Island, and we recognize that these lands have been and continue to be inhabited by many nations of Indigenous peoples since time immemorial. While we are gathering from multiple Indigenous lands and connecting through this virtual space, I would like to acknowledge where Policing Free Schools is based, and as am I. And that is what is colonially known as Ontario, specifically the original lands called Toronto, and acknowledge the original peoples of these lands, the Mississaugas of New Credit, the Anishinaabe, the Haudenosaunee, and the Wendat peoples who also call these lands home. And British Columbia Civil Liberties Association is on the unceded territories of the Musqueam, Squamish, and Tsleil-Waututh. Acknowledging as well with an African ancestral acknowledgement those who came here involuntarily, particularly as a result of the transatlantic enslavement trade. And so we honor and pay tribute to the ancestors of African origin and descent. With this stated, it is necessary to move beyond acknowledgements. This is not just a checkbox to be marked off. It is Indigenous, Black Afro-Indigenous, Black African diasporic, including across their intersecting identities, those who are disabled, neurodivergent, those who make up the two-spirited LGBTQIA+ community, those are who are most negatively impacted by colonial systems, by police, policing, and carceral logics, culture, practices, and systems across so-called Canada. And they continue to be systematically harmed and denied their humanity. It is both our individual and collective responsibilities to dismantle these systems. And thank you again for tuning into our National Digital Teaching Back to School series, part 1 of 3, Know Your Rights, Police in Schools, Digital Privacy, School Surveillance, and Arrest and Detention, hosted by Policing Free Schools alongside our partners, British Columbia Civil Liberties Association. The Know Your Rights teach-in was intentionally chosen to be the first of our 3-part Back to School series. This is a critically necessary teach-in because we know that until all schooling and educational spaces are truly police-free and collectively moving towards policing-free schools across so-called Canada, we need to ensure multiple harm reduction methods, and that includes Know Your Rights. My name is Andrea Vásquez Jiménez, gender pronouns she, her, ella. I'm the Director and Principal Consultant of Policing Free Schools, where we are dedicated to catalyzing systemic changes and a paradigm shift for the co-creation of transformative, healthy, equitable, life-affirming, liberatory, healing-centered, policing-free educational spaces. Policing Free Schools works alongside our partners across so-called Canada and makes part of an international movement working on these issues in solidarity with what is currently known as the US and UK partners there. With that said, let's jump right into the Know Your Rights National Back to School Digital Teach-in, where you will be provided legal information on students' rights when interacting with police in schools, rights surrounding digital privacy, school surveillance, and arrest and detention. You will learn about and get connected to resources, including Police in Schools, a pocket guide to your rights. And remember, the rights within the teach-in apply to all students across what we currently call today Canada, unless otherwise specified. Leading today's session are our amazing partners from BC Civil Liberties Association, Safiyya, Ahmad, Kenny Rogers, and Aislin Jackson. Safiyya Ahmad, gender pronouns she, her, works as staff counsel at the British Columbia Civil Liberties Association. She received a Bachelor of Applied Science and Master of Arts from McMaster University, a JD from the University of Ottawa, and was recently called to the bar in British Columbia. Before joining the BC Civil Liberties Association, Safiyya worked at the Community Legal Services of Ottawa, Immigration Refugee Branch, and the University of Ottawa Community Legal Clinic, Public Legal Education Branch. She has a strong interest in improving access to justice and public access to legal information about rights and remedies. Up next, we have Kenya Rogers, gender pronouns she, her, who is in her final year of the joint degree program in Canadian Common Law and Indigenous Legal Orders at the University of Victoria. She is a queer settler of mixed Ukrainian, Irish, and Black heritage and grew up on the territories of the Tsleil-Waututh peoples. Over the past 10 years, she has spent much of her time between the territories of the Squamish, Tsleil-Waututh, Musqueam, Songhees, and Esquimalt and Saanich peoples. Kenya holds a bachelor's and a master's degree in political science from University of Victoria. Kenya has an extensive background in community-engaged research with a focus on trauma-informed approaches to gender-based violence prevention and response. Kenya is passionate about grassroots activism and advocacy and has spent many years as an organizer and survivor support worker. She also has a strong background in facilitation and workshop development and has delivered trainings related to consent, gender-based violence, and student movement building throughout BC. As a law student, she is focused on building her skills for trauma-informed legal practice and access to justice. She hopes to use her legal education to honor decolonial, community-driven practices while contributing to meaningful transformation of the legal system. Outside of work, Kenya loves spending time with her friends and family, road cycling, live music, camping, and travel. And last but not least, Aislin Jackson, gender pronouns she, they, joined the BC Civil Liberties Association as Staff Policy Counsel in July 2023. They were born and raised in Mahakistis, colonially known as Calgary, on the Treaty 7 lands that are the traditional territory of the Niitsitapi and Tsuut'ina peoples. She's a settler living on the unceded territories of the Squamish, Tsleil-Waututh, and Musqueam nations. Aislin attended law school at the University of Toronto, where she was co-editor-in-chief of the Indigenous Law Journal and a student caseworker in the Family Law and Residential Tenancy departments of the school's legal clinic. Aislin started their legal career in the Treaty 7 area, representing First Nations in a variety of areas of law, including historical claims and child protection matters. They later practiced family and estates law in the Lower Mainland, serving legal aid clients and two-spirited LGBTQ+ families. Outside of law, she has a background in linguistics, Indigenous language documentation, revitalization, and computer science. In their free time, they practice soft arts, knitting, spinning, weaving, sewing, and quilting. Take it away.
So much for the wonderful introduction, Andrea. We're just going to share our slideshow as well. Before we get started, I would like to acknowledge that Aislin and Kenya and I are, as Andrea mentioned, calling in from the traditional and the unceded lands of the Musqueam, Squamish, and Tsleil-Waututh peoples. The BC Civil Liberties Association advances civil liberties and human rights, and Indigenous rights are civil liberties and human rights. And it's very important for us to incorporate those issues and those rights into the work that we do, particularly around the topics that we're going to discuss today. Next slide, please. So a bit about our organization. The BCCLA is a nonprofit legal organization. We promote, sustain, and defend civil liberties and human rights across BC and also across the rest of Canada. Some of the work we do includes running test cases. So that's where we bring lawsuits to the court to try to change the law in positive ways. We also review draft legislation from different levels of government. We intervene at all levels of court, and sometimes we'll these and Senate committees. We also put together booklets and presentations like this one today, and other resources to inform the public about their rights. Next slide, please. So just so everyone knows, we will be addressing some fairly heavy topics today. We'll be talking about arrest, detention, search and seizure, those kinds of issues. And people might find that traumatic or triggering. So please feel free to take breaks as needed and to take care of your needs there. This workshop is also designed to be about 90 minutes long. Once again, feel free to take breaks if you need to stretch, if you need to take care of your needs, do what you need to do. That's totally fine. We've built in some time for questions at the end of each of our sections. So what you could do is you could add questions to the Q&A function in Zoom. You could also just hold on to your questions until we reach one of the question sessions, which we'll each pause to do throughout the presentation. And just as a last reminder, we cannot provide you with legal advice today. So Aislin and I are lawyers, but we're not your lawyers. And if you are dealing with a legal issue, you would want to go to a lawyer who takes you on as a client and bring all of the relevant information to them so they can give you the best advice you need. And that's not something that we're equipped to do today. Our website does have some resources for how to access a lawyer. So you can check that for sure. All right. Next slide. Thanks. So we're going to start with some general information about interactions with the police. And this is going to be important for students who are dealing with police officers in schools, but it's also important for anyone else who interacts with police officers in school settings. So that includes teachers, that includes parents, that includes administrative staff, and so on. Our discussion today is focused around police officers and not around security guards. So that's just something we wanted to flag. We do discuss information about security guards a bit in our arrest handbook, and Andrea has posted the link for that in the chat. Next slide, please. So first off, the question is, what should you do if you're approached by the police for a casual conversation? And you'll notice I put voluntary in quotation marks because, of course, it can be very intimidating to be approached by an armed police officer who's asking you a bunch of questions, especially if you're a member. So some things to remember if you are approached in this kind of casual conversation way. You still have the right to silence, even in a casual conversation. You can choose to speak to the police. You can choose to engage. You can choose to speak to the police to report a crime, but you can't be forced to speak to the police in this situation. Something else to remember is that nothing you say to the police is off the record. And so what that means is that police can use things that you say or things that you write against you in a court, even if it's something that feels like a casual conversation. What does that mean if a police officer is also acting as your school teacher or as a gym coach? Well, that is one of the many reasons that we have a significant concern about police officers taking on these roles in schools. In our view, students still have the right to silence in that situation. And for teachers, this might be something that you would want to bring to your union reps as a potential issue as well. Next slide, please. So how do you know if you're in one of these situations that's kind of a voluntary conversation? So the key to remember is you can ask the police officer, am I free to go? And that is how you'll know whether or not it's a voluntary conversation. If the officer says, yes, you're free to go, then you can turn around and walk away. If they say, no, you're not free to go, that means you've been detained by the police. And we'll talk a little bit more about detention later, but the main thing to remember is that it means certain rights kick in right away, including the right to speak to a lawyer for advice. And if the police officer doesn't answer when you ask, "Am I free to go?" then you can repeat the question until they do as well. Next slide, please. So there are some situations where you do have to provide your name and address to the police. And what that usually means is you'll have to show a piece of ID to verify that that really is your name and address. So these situations include if you're under arrest, you do have to provide that information in that situation. If you're driving a car, so let's say you're pulled over for some kind of traffic issue, you'd have to provide your name, your address. In that situation, you'd also probably have to provide other information, things like your driver's license, registration papers, possibly the name of the car's owner if it's not you. And you'd have to provide this information if an officer gives you any kind of ticket or serves you with an appearance notice, summons. And these are various documents that basically state that you have to be in court at a certain date. And in those circumstances, you do have to provide that information. Something to keep in mind, do not give a fake name or address. That is itself a separate offense. Next slide, please. So now that we've gone over some general information about interactions with the police, we're going to get into some more specifics about the rights that young people have. Next slide, please. So when we're talking about youth here, we're specifically referring to people between the ages of 12 and 17. So if you're 18 and older, then you're considered an adult. And if you're under 12 years of age, then you're not covered by the Youth Criminal Justice Act. So youth under the age of 18 have the same rights as adults in terms of the right to remain silent, the right to speak to a lawyer, the right to know the reason that you've been arrested or detained, the right to be free from unreasonable search or seizure, and the right to express yourself and to protest peacefully. And so those are all rights that young people have as well. Next slide, please. So young people also have special rights that adults might not have. And so that includes police do have to inform the parent or guardian of a young person if they've been arrested or detained. Police also have to explain the situation to the young person in language that's appropriate to their age. So that might look very different for a 12-year-old as opposed to a 17-year-old. A young person can speak to both a lawyer and a parent, or if a parent's not available, then a close relative or a trusted adult for advice. And a young person can have a lawyer and a parent present during questioning by the police. And once again, if a parent is not available, they could have a close relative or a trusted adult there instead. Next slide, please. So some more special rules. Instead of arresting the young person right away, police must consider either taking no action or offering a warning or offering what's called an extrajudicial sanction. And basically an extrajudicial sanction means that the young person acknowledges that they've done something wrong and they have to complete certain court-mandated activities. And if a young person is offered that situation, that would be the kind of thing they would want to discuss with their lawyer. And then the last thing is youth identities are usually kept anonymous during the criminal process. So usually a young person would be referred to by their initials in any kind of trial proceeding. Next slide, please. Some things to keep in mind. As I mentioned earlier, a young person can contact someone other than their parent or guardian, but that's only if the parent or guardian is not available. So there's a specific order that it has to go in. Either you contact the parent or guardian. If they're not available, then the young person can contact a close relative. So for instance, an older sibling or an aunt or uncle. And if a close relative is not available, then the young person can contact a trusted adult. So that might be something like one of their friends' parents or a family friend. If the young person chooses an educator to fill that role for them, then some ways that educators might support them is by reminding the young person of their right to silence when they're being questioned by the police. Also by ensuring that the young person has access to a lawyer as soon as possible. And by keeping track of police behavior. So if a police officer is acting very aggressively towards a young person, to keep track of that information. If an educator is chosen as the young person's trusted adult, some things they should not do is they should not encourage the young person to give up their right to silence or to waive their right to speak to a lawyer. Some other things to keep in mind: a lawyer who's representing the young person is taking instructions from that young person. And certainly the parent or guardian can be involved in the process of advising them, but at the end of the day, the lawyer takes instructions from the young person. As we mentioned earlier, police cannot arrest children under the age of 12, but there still could be some very serious legal consequences. So that could include removing the child from their family, or it could include civil lawsuits, or it can include mental health detentions. And the last thing to keep in mind is that police officers can keep asking questions to a young person even after they've said that they want to remain silent. So people really have to work to exercise their right to silence in order to make sure that that's respected. Next slide, please. So we're going to pause there for a moment and just check if anyone has any questions. I do see that there's an answer, or there's a question in the Q&As to elaborate what a trusted adult would be and how that would kind of work. So the way that the hierarchy is structured is that we just discussed. That's from the Youth Criminal Justice Act. So that's why the young person would have to first try to contact their parent or guardian. And there's a question about what if the young person does not necessarily trust their parent or guardian? That's a great question. Just based strictly on the statute, that's still the order that you'd have to go in. But that might be something you'd want to specifically consult a lawyer about. And as I said, the kind of the trusted adult situation is someone who the young person's maybe not related to, but someone that they can feel they can rely on for advice in this situation. It's different from a lawyer. The young person also has the right to a lawyer, so they have the right to both of those things. So I hope that answers that question. Were there any other questions just about what we've discussed so far? And we'll have a couple more question periods as well. Once you've spoken, can you still exercise your right to silence? Yes, that's an ongoing right that you have. So let's say the police continue to question you, and then you kind of answer one of their questions. You still have the right to stay silent for all of their next questions. So there's a question about how the school act's duty of care would affect the teacher's responsibilities in students' interactions with the police. That would be a bit hard for me to address just because different provinces have different legislation and different schools also have different rules specific to the situation. So that would be something that an educator would probably want to bring either to a lawyer or to their union rep. and they would probably get a much better answer there. Right. Any other questions? Okay. I'm going to pass it on then to Kenya. Thank you guys so much.
Hi, folks, and thanks so much, Safiyya, for providing that overview and sort of setting the foundation of our conversation today. And I'm going to spend a little bit more time with you folks digging in detention and physical searches specifically, as well as what kinds of rights you have, what kinds of rights are triggered in certain situations. And as Safiyya mentioned, this is important not only for your personal understanding of your rights within these contexts, but in order for you to be able to communicate perhaps to students in your life what their rights are in these types of situations as well. So the first thing to note about arrest and detention is that police officers cannot arbitrarily and without reason make an arrest. In fact, there's 8 reasons that are specific as to why the police may have the ability to arrest you. And so we're going to start this section by going through those 8 reasons just to sort of give the context here. So the first reason that a police officer may have the ability to arrest you is because they actually see you committing what's known as a summary offense. So summary offenses are minor crimes, something like nuisance or vandalism. So if they see those types of acts being committed, their ability to arrest is triggered. A second reason is that they have reasonable grounds to believe that you have committed or you're about to commit what's known as a hybrid or indictable offense. So hybrid and indictable offenses are much more serious crimes. Assault and murder, for example, would fall into this context. And it's important to note here that it means that they don't actually have to see you committing this type of crime, but there must be a valid reason to believe that you either have or will commit a more serious crime. They can also move forward with an arrest if they have reasonable grounds to believe that you have breached or are about to breach some kind of state-ordered conditions of either a summons, an appearance notice, an undertaking, or a release order. So for example, if you were supposed to appear in court or you were supposed to follow certain conditions that are ordered by the court because of your involvement in another offense, and they have reasonable grounds to believe that you were going to contradict those orders, then they may be able to make an arrest. This one is more simple, but if there is a warrant out for your arrest, then police officers are authorized to make an arrest. So when there's a warrant out, the state has already sort of authorized that arrest to happen, and so the police have the authority to move forward with it. Another reason is that if police have reasonable grounds to believe that they are stopping a terrorist attack by or a terrorist act by arrest, this is very high. Another reason may be that if you have broken a law, such as a bylaw or a provincial law, and you also won't tell the police your name and address. So the combination of those things can trigger the ability to arrest you. And as Safiyya mentioned, refusing to give that information can in and of itself be considered an offense. Another reason could be if they see you doing what's called breaching the peace, and they have reasonable grounds to believe that you will breach the peace. So this could be behaving violently in public, for example. And then a final reason would be that there's a law that allows the police to arrest you for some type of specific reason or action. So a really common example of this would be laws around public intoxication. If you are intoxicated in public, then the police may be able to arrest you. So it's important to note that arrest isn't the only way that police may limit your ability to move. So we want to dig into what it actually means to be detained by the police. So the police detain you anytime that they're limiting your freedom to move around. So this could look like physically restraining you, but it could also look like blocking your path or actually making you believe that you aren't free to go. And so, as Safiyya mentioned earlier in her section, it's really important to remember that you can always ask a police officer that you're interacting with whether or not you're free to go. And if the answer is no, then that means you are being detained by the police. And it's really important to know whether or not you're being detained because there are a range of rights that kick in immediately when you are in a context of detention. So what are those rights? You have, as Safiyya mentioned, a right to silence. And it's important to note that this is in the context not only of in speaking, but in writing as well. And while you do have to give information such as your name and address, you do not have to state other things such as your gender identity. And you can maintain this right to silence even if police continue to question you. You also have a right to a lawyer, and the police must then connect you to a lawyer once you request one. However, in some cases, there may be a delay in getting you access to a lawyer. For example, if you're in a situation where you're driving a car and the police officer has pulled you over and detains you. And then finally, you have a right to know why you are under arrest, and you can demand that you detaining you. Another thing that's important to note is in the context of an arrest, there are certain abilities and authorities for police officers to search you. So this is called a search incident to arrest. And this means that the search that is happening or is going to happen is related to the arrest that's been made. So police have some authority to conduct a search during an arrest, including searching the person, any of your belongings, your car, or nearby surroundings. But it's important to know that the search can only be for the purpose of securing evidence. So, for example, if you're being arrested for a particular crime, the evidence should be in the pursuit of the crime that has happened. Or it can be for the safety of the officer or the public. So, for example, making sure that you don't have a weapon that could be used on the officer who's conducting the arrest. However, if the arrest is illegal, any search pursuant to that arrest is also illegal. So the evidence that gets collected through an illegal arrest can be challenged in court. So it's really important to be aware of this and to collect any information that you can, because if you can potentially share that with a lawyer in the future, it may support your evidence in court. And one of the things that can render arrest illegal is police behavior and their use of force. So the police are only ever allowed to use as much force as is necessary to arrest you or to ensure safety. And anything that it goes above that is excessive force. And excessive force can render the arrest illegal and any subsequent searches also illegal. So as I mentioned before, that's why it's really important to tell your lawyer about police behaviors if there is an interaction, or to advise other folks who may experience police interactions to be thinking about this. Because if there is evidence of excessive use of force, you can also file a police complaint or actually file a lawsuit against the police for their behavior. And this next note is a little bit heavy to think about, but if you have any cuts or bruises or any physical evidence as a result of your experience with police interaction, it's really important to, if you can, go to the doctor and take photo evidence of the injuries, because this evidence can be used, as we've said, to show that the arrest was unlawful, And it's also really important to get treatment and care for the injuries that you may sustain. So we've mentioned a little bit about police and searches, but I'm going to spend a little bit more time talking specifically about physical searches, both in the context of police interactions, but also in schools and with school officials. So starting with the school's context, school officials such as principals, vice principals, or teachers can actually search students' phones, lockers, and school bags when it upholds particular school rules. However, they do have to meet a certain range of criteria when doing so. So first of all, they must have authority from the school code and the provincial laws. In BC, for example, this falls under our School Act, and it may fall under the School Act in other provinces as well. The search also has to be minimally intrusive and sensitive to things like privacy and gender. And the extent of the search should be justified by the seriousness of the rule that's been broken or supposedly been broken. So there has to be an appropriate balancing done. And finally, the school official must have reasonable grounds to suspect that there is a school rule violation going on. So what's important to note here is in the context of police in schools is that police officers cannot use the authority of student officials as their agents to avoid going through the appropriate channels that police officers have to go through in order to do these types of searches, such as getting a warrant before they're actually conducting searches. And this is really important because in some instances, what we see is that school officials actually have more powers to search students than police officers would themselves. So going to the next slide, police officers can only search your things in certain situations. They can only search students' things in certain situations. So you can be searched if you give the officer permission, of course. You can be searched if the police have a warrant to search or if they have authorization through specific laws, or if you've been arrested, and as we mentioned, the search is incident to that arrest. However, in the context of search, you are entitled to what's known as a reasonable expectation of privacy. And this expectation of privacy is different in different situations. So a situation where one would have a very high reasonable expectation, you're at home in your bedroom. However, there's a lower expectation of privacy over things like our school lockers. And we have no expectation of privacy over things like fingerprints or hair samples that are left behind at a crime scene, for example. And understanding these different levels of expectation of privacy is important because it also shifts the authorities and abilities of police officers who are searching. So in a context where there's a very high reasonable expectation of privacy, police actually need reasonable grounds to believe that you have or will commit a crime. And they have to follow really special rules when they are conducting a search. When there's a low reasonable expectation of privacy, the police only need reasonable grounds to suspect you have or will commit a crime. So we're looking at belief over suspicion in those contexts. And then finally, when there's no reasonable expectation of privacy, things that are left behind, for example, the police are free to search. So I'll just share a couple more examples. So when you're in your car driving, there's a fairly low reasonable expectation of privacy. Your cell phone, on the other hand, has a very high reasonable expectation of privacy. This is important to think about when we're considering what kinds of authorities school officials may actually have in terms of access to students' technology. And my colleague Aislin is going to dig a bit deeper into that in a moment. Your garbage, on the other hand, has no reasonable expectation of privacy. And your friend's home, if they consent, there's no reasonable expectation of privacy. And then your body has a very high reasonable expectation of privacy. And something I just want to end on here when considering the context of your bodily autonomy and expectations around privacy is that for members of the queer community, folks can actually choose the gender of the person who is searching you. So if you end up in a situation where a search is about to happen, you can request the gender of the person who is going to conduct that search. But there may be situations where the police feel that there is an emergency or that they have to conduct the search without waiting for an officer of the gender that the person has requested. And in instances like that, it's really a good idea to speak to your lawyer about these situations because there actually may be a rights violation that has occurred. And it's important to hold police accountable to their decisions about what an emergency is or what a reasonable amount of time is to wait for an officer of the gender that's been requested. And just a note here that you can always check the policing guidelines of your own community for more information about what in your municipality or region are. So with that, I'll wrap up my section and leave some space for questions about any of the things that we've discussed here.
And I see we have a few questions already. So the first one I'm reading here is, how can the police prove any of these reasons for arrest or detention? Which is always a good question, because when we're coming into court, the court only in very rare cases will take facts that are not proven on the record. So proof is always important. Somebody's testimony is proof. So an officer can swear an affidavit or get on the stand and talk about what they knew and what they believed based on that. And then it's for the court to evaluate whether or not that meets the legal standards of reasonable grounds to believe. They don't need to prove that to you in the moment that they're doing the arrest. All this is going to be determined later in a court. So I hope that answers the question. There, all right. And then, can you rescind your permission to search? That's a tricky one. Safiyya, do you have any insight into that?
So my understanding is, yes, you can rescind your permission to search. Just be aware that if police officers are sort of in the middle of a search, that they could potentially argue in court that that was part of they found evidence, etc., while they were committing that search. So that might be something to be aware of, but you can certainly state to the police that I do not consent to this search. In terms of drug sniffer dogs, that is, yeah, that's an interesting case. And basically, drug sniffer dogs, there's still a standard of reasonableness that has to be met. And we do have a bit more information, I think, about school property and school lockers in the Digital Privacy Rights for Youth Guide as well. But broadly speaking, a principal authorizing searches would be acting as an agent of the police. As Kenya mentioned, principals can authorize their own searches of lockers in order to uphold school rules. But if they're doing it so that the police can have access to those lockers, then that is acting as an agent of the police. So there.
Yeah, I'm just going to add to that I think the question will come down to what is the purpose for the search, because if the purpose is to enforce school rules about having substances on campus or student use of substances, then it's more likely to be authorized within the school's powers. And part of that is because of the way the Constitution is structured, the way our Charter of Rights and Freedoms is structured. So the reason we have under Section 8 of the Charter a guarantee against unreasonable search and seizure by the state. But all of those rights in the charter are subject to any limitations that can be demonstrably justified in a free and democratic society. So if we have case law from the Supreme Court of Canada saying that school officials are allowed to search for the purpose of enforcing school discipline and keeping a safe school environment, right? So the purpose is different from a police search, where the purpose is to collect evidence that's going to be used to criminalize somebody. And so the purpose of the search is going to become very important if this ends up going to court, this kind of situation.
Yeah. So the next question is about if a BC teacher suspects that a colleague is operating as an agent of the police, how can they intervene? Probably what you would do is you would tell the student or their lawyer, and let the lawyer kind of use that information as best as they can to assist the student. Beyond that, in terms of things like disciplinary proceedings, we don't really have that information today, and that would kind of, again, depend on the jurisdiction and the specific rules around the school. So that would be something that you could check with your own school code of conduct and potentially with your union.
Yeah, again, this goes to the purpose of a search. So if you think that a colleague or an administrator at your school is searching essentially on police orders in order to collect evidence for the police to use for law enforcement purposes, then that's something that, as Safiyya said, it's a good idea to tell the student about, because they can use that information to challenge the search in court if it ever comes to that. And also, as a general note, that it's always a good idea when you see something sketchy going on with respect to the police behavior to take notes as it's happening. These are called, in the law of evidence, contemporaneous notes, and they're really helpful because the human memory is malleable. Written or typed or made a voice recording that's at the time something was happening, then your memory is going to be more reliable at that time than it will be however many months later that you're in court giving your evidence. So contemporaneous notes are really good practice whenever you are perhaps a trusted adult sitting with a student who's being questioned by police, or if you see your colleagues working in this kind of way to serve the purposes of the police. And I think this kind of segs into the next question, which is, what does it mean to be an agent of the police? And does it mean that that person can be held accountable legally? As far as I know, we don't have any case law about educators being named in cases that are alleging breaches of charter rights for acting as an agent of the police. But when we talk about that in this context and how it's improper, it really comes down to what is the purpose of the search. It is improper for school administrators and educators to use the broader search powers that they have in order to keep, to maintain order in the school environment, to serve this different purpose, which is police and law enforcement and gathering evidence for criminal prosecutions. So if you're not going to need to do the search yourselves for the purpose of enforcing the school rules and all of the proper powers that come from your school act or your education act or whatever the name of the piece of legislation may be in your jurisdiction. But instead, it's a situation where the police say, look, we have reason to believe that this person might be affiliated with this gang or something, and we want to search their locker just to see what we can see. That's improper because it's not connected to the school powers or to the school's code of conduct. So I hope that's clarified it.
Yeah, and I'll just add really quickly that basically the standard that is set by the court is, the question is, was the school official going to conduct the search anyways in order to uphold a school rule, right? So there might be a situation where a school official believes that a student brought drugs into school, and at the same time, a police officer is investigating students bringing drugs into the school. And so then the question is, was the school official already going to search a person's locker, for instance? And that's kind of the standard that courts will use to determine if the school official was acting on their own and according to their own authority, or if they were just and in the latter case, usually that would be an argument brought forward for excluding the evidence at a trial, for instance. And then just the last question about kind of the evidentiary issues about helping someone with their notes. Yeah, that's getting into evidence law and how you would argue about like an affidavit as opposed to a voice recording, as opposed to various other things. So that would be something that, depending on the situation, you would want to speak to a lawyer about, whether you can use the evidence that's collected in this way. In general, it's useful to collect evidence and then bring it to a lawyer, rather than not collect the evidence and then find out later that, oh, you could have used that in a court. So I hope that's helpful in terms of addressing that one.
Although I will note that it is cleaner from an evidentiary perspective to have the person make their own notes. This is because I'm sure you've heard about in TV or movies, there's something called the hearsay rule. And that means that you can't, with certain exceptions, introduce evidence in court that something is true based on somebody else telling the witness that. It has to be the witness's own observations, right? And it's not necessarily the case that those notes will not be helpful if they're made with the assistance of a second person or dictated. But at that point, the person who's taking down the information, if they're not the one who's actually experienced the situation, they can't tell the court whether that's true or false. They can tell the court whether or not they believed the person who told it to them. But then we're kind of getting into this game of telephone that's not really permitted by the court, right? So the cleanest way for people to do this from an evidentiary perspective is to make your own notes that you can then use to refresh your own memory if you're ever called to testify.
Okay. Just any other questions before we move on?
All right, and then I'll move on and take us into cyberspace. So privacy in electronics is a really important area of the law that's developing rapidly as technology develops rapidly. There are, and also our phones collect so much information about us, not just the information we put into like our contact, our address books, for example, like any fitness tracking that you may use your phone for, step counters, all of that stuff. But it also collects information that you don't necessarily know it's collecting. They're GPS navigators. It's very difficult to completely delete a video or a photo that you've taken to the point where it can't be recovered by forensic analysts. So phones, this is part of why we have such a high reasonable expectation of privacy in our phones, because really somebody's phone, especially with forensic investigators having access to it, can tell you almost everything about that person, including the things that they think about or wonder. So just like with physical searches, in schools, there can be broader rules for teachers and principals to confiscate or search electronic devices. Here in BC, our government recently announced that it would create a cell phone ban in schools, for example, which would motivate and justify teachers confiscating these these concentrated pieces of personal information from the students. Police, on the other hand, generally need a warrant to search your phone and other electronics. However, just as with your physical environment, if you've been arrested, police are allowed to briefly search your phone, but it's subject to very stringent rules because this is a search incident to arrest, not a general fishing expedition for anything you might be involved in that might be sketchy. They can only search your phone upon arrest if the arrest is lawful in the first place. So if the arrest is unlawful, then a search of the phone that's incident to that arrest is also going to be unlawful. Or if they have one of, or no, not or, I'm sorry, I misspoke. And it has to be a lawful arrest, and they have to have one of 3 specific law enforcement reasons to search, either for safety, whether that be of the public in general or the officers who are conducting the search, for preserving evidence, or for finding evidence. And that, just like with the physical search, is related to the offense that you're being arrested for. The nature and extent of the search has to match one of those reasons. So if they're looking to preserve evidence that's related to, say, for example, a protest activity, and they think that some people smashed some windows, so they could, and they think that you're one of these people, so they could perhaps look through your recent messages to see if you'd texted your buddy about how are we going to get away from the scene after. They couldn't go delving into months-old messages or open up your search history, that sort of thing, to go looking and snooping around and see maybe what you're doing on dating apps or whatnot. That's not relevant. It doesn't match the reason for the search. And they also have to take detailed notes while they're doing the search about what they searched and why, so that a court can review later to make sure that they've stayed within these boundaries. So filming the police is also, it's an important right that people have that can provide us evidence we wouldn't otherwise have of police misconduct, for example. And you have the right to take photos and videos of the police while they perform public duties. Keep in mind, though, that police do need to be able to direct people in order to maintain safety. So it's in your best interest to follow directions on where to stand. If they're doing this in a way that is obscuring your view of the police activity that you actually want to take, then you can do the same thing. Take notes at the time or as soon after as you can. And this can also found a police complaint. It's not a good idea to yell or swear at the police while they arrest somebody else, because not only are you escalating the risk to yourself that you might catch a charge for obstructing the police, for example, but it could have negative outcomes for the person being arrested themselves because it escalates the situation. And I will add that there are some situations where police, we have heard of police asking people to destroy footage that they've taken of the police. We're hoping that this behavior is going to be less common moving forward after an RCMP officer was recently convicted of obstruction in Prince George for doing just that at the scene of a police incident where they killed a Wet'suwet'en man. And bystanders were asked by this officer to delete their footage. So that there was a criminal conviction of a police officer for that. So we're hoping that that sets a precedent that discourages police from doing that sort of wrongful behavior in the future. As with any sort of police misconduct, you have to calibrate your safety in the moment. The safest time to assert your rights is in a courtroom after the fact, which is sometimes cold comfort. But escalating with the police can lead to more extreme violations of rights and So I also want to mention intimate images. This is, this is an area where the law is actively advancing and evolving, and politicians are really trying to address the situations that we've seen where young people are either exposed to this sort of exploitation, but also from their peers through bullying. So intimate images is a legal term for images that show someone who's either engaged in sexual activity or unclothed. The exact definition is going to vary province by province. And non-consensual distribution of intimate images is a legal term for something that's often colloquially referred to as revenge porn, where somebody will upload or otherwise distribute intimate images of their target in order to cause them psychological distress and damage their reputation. This is something that has been involved and implicated in some high-profile cases of young people's suicide. And earlier this year, a 13-year-old in Quebec was arrested and charged with child pornography, among other offenses, for engaging in this kind of conduct. So it's something that I wanted to include here so educators would be aware of both the effect that this can have on targets of this activity who may be in your classes, and the remedies they might have available to them, but also so that you can let your students know who might be inclined towards this kind of activity and not take it seriously, that it is a very serious issue and can expose them to all sorts of legal liability, including serious criminal charges. So the intimate images legislation that's coming in, most provinces now have some version of a statute that deals with intimate images. Unfortunately, Ontario and Quebec don't at this time, but the other provinces do. And I've listed them here for your reference so you can look at the act that's in force in your jurisdiction and see what it provides. These acts don't change the criminal law. And again, when we're talking about young people, it is a criminal offense to distribute child pornography. But they also create non-criminal remedies for victims to have the images removed from the websites they've been uploaded to, or even de-indexed from search engines so they won't appear in search results. They also allow for people to get monetary compensation from whoever uploaded them in the first place. So these are really great remedies because they don't rely on, and they can actually address the harm, which criminal sentencing doesn't really do. Criminal harassment is also a crime that could be involved when people are engaged in this kind of activity. That's when there are repeated communications that make somebody fear for their safety or the safety of somebody that they know. And certainly this sort of revenge porn or non-consensual distribution of intimate images could qualify in appropriate circumstances. Many of these acts have special provisions to help young victims to have these images taken down. So for example, in BC, our Intimate Images Protection Act allows people as young as 14 years old to apply in their own right, without the involvement of a parent or an adult, for a takedown order from the Civil Resolution Tribunal. Other provinces will address it to varying degrees, such as in New Brunswick, I believe it specifies that any court actions related to intimate images are going to use pseudonyms for young people who have been victims. So it's a good idea to take a look at your provincial legislation and see what the parameters are for young people to be able to access these remedies themselves, or to authorize others to do so on their behalf. If you know a young person who's been the victim of non-consensual intimate image distribution, you can encourage them to get in contact with a local youth legal clinic or a lawyer to learn what their options are. And in BC, for example, that would be the Society of Children and Youth BC. All right, so are there any questions about this privacy and electronics part? I see there are a couple. Right, so the first one, is asking if we have any suggestions for what to do if we witness an arrest where we believe somebody's rights have been violated and have gathered video footage or notes, but you don't know who the person is and you don't have a way to get in contact with them or their lawyer. This is a tricky one because really we want to leave the agency over what happens with that information in that person's hands, but you can make police complaints in many jurisdictions about things that you've witnessed, but that you weren't the target of. So if the conduct is such that you're really concerned, you can make a police complaint in your own right about what you observed, and submit your evidence to the investigating agency, which is going to depend on the police agency and also on the province. So here in BC, if it's a municipal police agency, it would be the Office of the Police Complaint Commissioner. It goes to the Civilian Review and Complaints Commission. And that's going to vary depending on what police agency you're actually looking at and where you're located. You could also, and I would be very cautious about this and not upload any video or images out of respect for that person's privacy, but you could put the word around on social media or in your local community that you witnessed this behavior, and offer to speak to somebody's lawyer and say you're willing to give evidence if they want to pursue something and your evidence would be useful. Right, and here, if a teacher has taken away a student's phone, do they have the right to get it back in order to film the police? No, and then there's an apology if the question doesn't make sense. It makes perfect sense. You have a right to film the police, but you don't have a right to have the tools that you need to film the police. So I haven't conducted research on this specific question, but based on what I know of the law generally, I don't think a student would get very far arguing that it was a breach of their rights to not give them their phone so that they could film the police. It's not a breach of somebody's rights that the police or a third party don't supply the tools that they need to film the police. It's simply a breach if somebody prevents them from doing so when they have the means to do so. Safiyya, do you have a perspective on this you'd like to contribute?
No, nothing to add specifically. I think that's a great answer. This might also be something that teachers and educators kind of consider when they're developing legislation or school codes of conduct in terms of the different reasons why students might want to have access to cell phones and to make sure that they have access to their electronic devices.
And certainly in that situation, if you are the educator in question and you, let's say there's a complete phone ban in your school, so you're not authorized under the school rules to return those devices to students, there's nothing stopping you from recording with your own device. Although one thing I should mention is that police do have the ability to confiscate phones if they believe that there's evidence of a crime on those phones. And your right to silence extends to your passcode for phones. But if you have a facial recognition lock on your phone, they don't need a passcode. They don't need you to say anything. They can hold your phone up to your face and use that to unlock it. We also, in the United States, of police using somebody's mugshot to unlock their phone, which was left behind. So it's something to think about carefully when you enable biometric locks on your phone, is that they might be less secure in a police search context. One piece of advice I always give to protesters, for example, or people who are in situations where there's a real possibility that police may want to confiscate their phones for the preservation or collection of evidence, and who is that police may or may not be able to crack your phone. They will tell you that they can crack your phone, whether or not the your specific model is one that they're able to unlock and use that to try and convince you to give up your passcode. But whether or not that is true, they can still confiscate your phone and you could potentially be without it for months. So that's something to consider carefully. And if there's a situation where you know that police are going to be involved and there's a risk that they may want to confiscate your phone, you may want to have a second phone for those situations, or leave the phone at home and communicate via walkie-talkies or similar. And at the very least, you want to back up your phone so that it is less of a tool to get you to share your passcode and consent to a search. The threat of you not having your phone for months at a time while the police lab tries to crack your passcode. So it's just some other phone tips for dealing with the police that aren't necessarily specific to a school context. Are there any other questions at this time? Seeing none, I will proceed. So safety tips, and I touched on this earlier, but it is usually not in your best interest to fight or physically resist searches or arrests. It can be dangerous, and you could face criminal charges just for the resistance, even such as obstructing justice or assaulting a police officer. Even if those charges ultimately don't go through in court and don't hold up, it's still expensive and stressful to be charged criminally and to have to defend yourself. You can say verbally, I do not consent to this search, and just passively allow it to happen, and that will maintain your rights. You can also make sure to ask for a lawyer upon request, or upon arrest, rather. You might feel frustrated, angry, embarrassed, or scared during interactions with the police and the criminal legal system, which is understandable and normal in many cases, especially if you belong to a community that has experienced over policing and discrimination, like those in the queer community, racialized groups, or other groups that have been heavily policed. Remember that you have legal rights and you can enforce those rights. The safest time to do that is after the fact in a courtroom in front of a judge who is charged to interpret and apply the Constitution, rather than in the heat of the moment with a police officer who may become escalated. Speak to a lawyer about how to do so in your specific cases if you need to enforce your rights. And then we have some resources that are available free of charge from our website, and that Andrea has helpfully shared the links to in the chat at the beginning. We updated our arrest handbook in September of last year, which is available for free on our website as PDF in a variety of languages: English, French, Spanish, Punjabi, and traditional and simplified Chinese. We also will ship these resources while supplies last, free of charge. If you want to have them on hand in your classrooms, at your school libraries, at any other spaces where people might want to access them and gain circulation. We want this information to be out there. Similarly, the Police in Schools Pocket Guide we developed last year based on the information in the arrest handbook and tailored to the students dealing with police in schools, which is available for free on our website and can be ordered for free, same as the arrest handbook or the pocket-sized version of the arrest handbook. Unfortunately, that's only available in English at present. We also have a magazine style publication about digital privacy rights for youth that goes in some detail to the case law around the searches by school administrators as well as police. And that's available for free from our website as well, in both English and French. And we've produced videos on the subject as well. So those are great resources to further your learning and to share with young people in your lives. Thank you so much for your time and attention today. This concludes our presentation. You can find more information about our organization and our work, as well as more resources that we produce to educate and inform the public at our website, bccla.org. Thank you so much, and thank you to Policing Free Schools for organizing this teach-in.
So much gratitude to BC Civil Liberties Association partners, Safiyya Ahmad, Kenya Rogers, Aislin Jackson for providing this incredibly important legal information, because once again, we know that until all schooling and educational spaces are truly police-free and collectively moving towards policing-free schools across so-called Canada, we need to ensure multiple harm reduction methods, and that includes know your rights. And remember, know your rights, know your reality. As our US-based national campaign partners, Advancement Project and the Alliance for Educational Justice remind us, the only rights we have are the rights we organize for. Extending further gratitude to all y'all, to the young people, students, parents, caregivers, guardians, educators, administrators, elders, community organizers, and community members, wherever you may be from coast to coast to coast. Thank you for joining us in this critically necessary National Back to School Digital Teach-In. Know Your Rights, Police in Schools, Digital Privacy, School Surveillance and Arrest and Detention, hosted by Policing Free Schools, alongside our amazing partners, British Columbia Civil Liberties Association. And folks, the resources are available, and so please do connect to the resources and connect with us if any further support is needed. Once again, thank you all so much for joining us, and have a beautiful day.